I studied at Newcastle University for my first degree, did law, and then after that I went straight into a PhD at King's College London, and then after that I got my first lectureship at Leicester University. So I never practiced, I never qualified as a lawyer, which is a bit funny given the subject that I teach, trusts, is quite practitioner oriented. But after that I spent a few years back down in London teaching again at King's, and then a very brief period at Liverpool before I ended up here at Warwick. And a few years later I went back and did a part-time history degree at Oxford, which was something that aligns with my research interests, which were veering into historical areas. So there's that as well. So I've been at Warwick for about 15 years. I joined as a reader and then was promoted to professor 7 or 8 years ago. The thing that inspired me to pursue a career in academia was getting a job as a research assistant at the end of my second year, it was, when I was an undergraduate, for 2 of the professors in my department. So I spent a summer being sent off to the library on their behalf. And this was back in the day where there was a single computer in the law department where you could look on the legal database. You had to log in via Telnet, this old-fashioned black and white screen. You had to type in your Boolean operators. It wasn't just a case of logging onto Westlaw or Lexis and finding everything now. So if you wanted to know whether or not a particular topic had been covered in a journal, you would have to go to the library and look in the index of that particular journal and then scan through the title of every article over the last 50, 100 years, whatever it was, in order to find out if there was anything relevant. And that sounds very archaic and boring now, but I just fell in love with being in a library and carrying out that sort of old-fashioned research. So my main areas of interest, this is both for teaching and for research, are the law of trusts in general, and charitable trusts and the law that relates to the voluntary sector in particular, which is a sort of subset of the law of trusts. And what actually made me interested in that originally, again, goes right back to my undergraduate days. I was very into mooting. Me and a friend of mine who went off to become a barrister, he's just been made a QC a couple of years ago, in fact. We were given a mooting task in our second year before we'd studied trusts, and it was a charity law problem. And of course, we knew nothing about the subject at all, so we had to go and research not just the answer to our particular little moot problem, but the area of law itself. And so I think we both felt at the time that we'd taken ownership of this little particular topic that none of our cohort had studied yet, wouldn't study for another year. And so I became interested in that area. And then I was lucky enough to see a PhD advertised in that particular area with funding already attached down in London, which I applied for and was lucky enough to get. And I've been interested in that area of law ever since. I think the most important thing to me when it comes to teaching is for the students to feel that they can ask any question in the seminars and not feel that they're going to be belittled. They might be challenged if what they say is wrong, but there are no stupid questions, because I'm always very much of the opinion that if a student is sitting there in silence, worried that they don't understand something fundamental, you can pretty much guarantee that half the rest of the class will also be confused on that same point, and it's probably that we haven't explained it well enough. Or it may be, if it's a trickier question, that they're right to be confused because maybe there isn't a proper answer. And so we want students to feel that they're comfortable speaking up in those sorts of situations, because the rest of the class is sitting there probably wondering the same thing. And more broadly than that, I suppose it is the idea that we're all learning. I'm not there as the fount of knowledge, none of us are in the seminars. And so I want students, first of all, to think critically about the things that we tell them in the lectures and that they read in the books, but also to understand that they are going to hopefully ask questions where we don't know the answers. And that's often the best seminar, is when the student comes up with a question and you have to sit back and think, that's an excellent question. Do not know what the answer is. And then we can have a chat about the fact that we don't know what the answer is, and we can speculate, and maybe we'll go away and we'll agree that we'll all see if we can find out what the answer is for next time. And that can generate further discussion down the line. So I have just finished working on a particularly interesting, to me at least, book chapter looking at an old 18th century charity law case where the first legal definition of charity came from. And it's been a particularly interesting project because the old-fashioned law reports from back in the day vary hugely in terms of how much detail they give, and this particular case has a 3-line judgment, and so there's just nothing to go on. And so I went into the archives and I dug out all the old papers to find out exactly what was going on behind the scenes in the case, and actually the facts don't quite match up with what the judge said in the judgment. So something has gone awry somewhere along the line, whether it is the judge, whether it's the reporting. So it was interesting to be able to shine some fresh light on this really old case that a lot of charity scholars take for granted in terms of the definition which we quote regularly. I've got another project where I'm writing an entry on the history of charity law a little bit more broadly for a bigger encyclopedia on not-for-profit law. But then my big project at the moment, which I hope the publishers aren't listening to this, I've been putting off tackling as much as perhaps I should have done because lots of little interesting projects keep coming along. But I'm writing a book for Edward Elgar on commercial trust law, which is very different, very modern, contemporary. And what's interesting about that, first of all, it matches up with our Term 2 Trusts module, Contemporary Issues in Trust Law. So that's a research-led module, and the book is going to be influenced by the seminar teaching and hopefully vice versa. Lots of trust law rules have been developed over the centuries based on a sort of traditional family settlement where someone is looking after the family home for the benefit of the kids, that kind of thing. But the trust has got lots of commercial uses today, and that's meant that some of the rules have had to be changed. Some of the rules are not quite fit for purpose, and so that's one of the issues that I'm trying to grapple with in that, or at least I will be when I've got enough time to give it as much attention as I ought. There's quite a lot of intersection with other disciplines, so I'm quite interested in the historical side of things, particularly because charity law is inherently historical in its nature. The modern definition of charity that we use today, although it's been tweaked, essentially comes from an Elizabethan statute, and there are certain elements of modern charity law rules that go back even further to canon law before that. And that's something that we look at quite a lot in the Charities, Civil Society and the Law module, which is another one of my research-led teaching courses that runs in Term 2 for second and third years. But aside from the historical side of things, I think it's important that we understand how the law operates in context. Everybody at Warwick is going to say that. That's very much our shtick here. But charity law in particular, because we are trying to deal with how civil society operates, and it's this big amorphous blob that includes a whole range of different organisations, and it's got a different set of motivations, the people who are involved in it, compared to, say, a private firm that's out to just try to make a profit for somebody. And so there's a huge amount of material that's been written from the perspective of political science and economics that helps us explain that sector. And so I try to make sure that my teaching and my research is informed by those disciplines as well. So, as with all my colleagues, I've got a couple of office hours, consultation hours every week where students are welcome to just turn up without an appointment. I'll be sitting here in my office waiting to chat, usually with some biscuits on the table in front of me if they're lucky. But people are welcome to knock on my door if they're passing any other time. It's just I might not be in, I might be teaching. And of course, if students don't want to come into campus just for the sake of a quick chat with me, they're very welcome to send me a message on Teams during my consultation hours, and we can have a chat online instead.